I wish I had a blanket answer for this one, but it really depends on your own governing documents. If there is a rule already in place in the governing documents about tennis courts or anything like that in terms of hours of operation, for example, that would need to be amended through the declaration, not through a rule, which would require a membership vote. Let's say it's silent, right? Then the HOA could pass a rule just with a board vote. The membership would be able to speak on the subject and obviously voice their concerns. But at the end of the day, the board's going to make a decision. And if they make a decision against the membership's interests, we'll see what happens at the next election, right?
I'm Luke Carlson, and for almost 2 decades, my law firm, Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of Carlson Law. Welcome back to the podcast. We are very excited today because we have a very special guest. Before I introduce our guest, though, I'm going to introduce Marty, our producer. Welcome.
Good morning. Good to be here. Thanks for having me.
Good to have you. And we have headphones on, which means we're zooming someone in. So today we have Keith. He is our partner in Florida doing incredible work. Keith, welcome to the show.
Good morning, Luke. Good morning, Marty.
Good morning.
Welcome. And so, Keith, you were doing phenomenal work in Florida, representing homeowners. And, I would like to start, though, by sort of getting some background. Where did you go to school? Let's start there. That's a good, I think that's a good starting point.
Of course. I went to the University of Florida. I'm a Gator for undergrad. After graduating there, I went to Tallahassee, FSU for law school. So I'm a house divided within one person. That's where I met my wife, and we got married about 10 years ago, and we have a 5-year-old son, and we're about to have our second child, a girl, in June.
Congratulations.
You got a very busy house. That's going to be a loud house.
Oh yeah. Don't we both know?
All right. So today's topic, again, we're Florida centric because you're on the show. And I love the topic, and this is something that you engineered. I think it's very important. And it's navigating the enforceability of HOA rules in Florida. I think that's a hot topic.
As we've done this show over and over, I'm always impressed with the laws and how quickly Florida moves with making changes. And it feels like it's constant. It's always something that's changing over there, which is actually, and usually from what we've seen, for the better. We've had Jeff on the show multiple times, and it always seems like they're in the lead with that. So it's interesting to kind of dissect this underneath that umbrella of the new rules.
Agreed. Looking at Florida, I mean, it seems to me that they're always moving in the right direction. And when I say that, I mean, it's protecting the homeowner against abusive HOAs. So Keith, go ahead.
I agree. With these, especially when it comes to rulemaking, there's been recent updates there, which requires more transparency and obviously notice to homeowners. And also, it allows for homeowners to become more cognizant of the rules in their community before any violations get issued. So Florida is definitely doing more to protect our homeowners now.
Exactly. So let's do the introduction in terms of the role of HOAs in Florida communities, the importance of enforceability versus sort of unenforceable rules, because that's really what you're dissecting here. You have rules that are enforceable, but then you have another bucket where they're unenforceable. And I think that's really the heart of this show.
Of course. It comes down to a couple factors there. There's just baseline rules that are unenforceable, and we could discuss those that interfere with your constitutional rights, whether it be under the Florida Constitution or the United States Constitution. There's also rules that are unenforceable just under your association alone, because your governing documents, the rules that are in place already, prohibit those rules. So there's multiple ways that these rules could be viewed as enforceable or unenforceable under multiple scopes.
Well, let's start there just real quick. So we're talking about, when we look at an association, and it's the same for California, you have sort of the governing documents. Typically it's the CC&Rs, it's bylaws, it's all of these bylaws as well. Now, how do you define rules? What actually is an HOA rule? How do you articulate that?
Great question. Rules come in many forms. The rules can be found in those covenants, the CC&Rs that you refer to, but the HOA is allowed to pass rules outside of those CC&Rs that one wouldn't be aware of in the public record. They're normally provided to the homeowners through a printout or on a website. And those rules can be put in place in multiple procedures, but they cannot conflict with those governing documents. Those documents are already in place.
So would an example be, I'm living in a community and all of a sudden I get a pamphlet that says, here are the new rules regarding golf carts. I use golf carts because I assume there's a lot of golf carts in Florida. But would that be considered, is that what we're looking at here?
Yes, of course. Golf carts are definitely something that would fall under those rules. A lot of times the covenants, the CC&Rs, are silent on something like golf carts. So when they're silent, the HOA is allowed to step in at that point, depending on what their covenants say, if they're allowed to pass a lot of rules. And luckily, HOAs are allowed to pass these rules, but they have to go through obvious barriers with the homeowners to go through notice and maybe even pass membership votes.
Go ahead, Keith. Didn't mean to cut you off.
Yeah, and these rules, such as a golf cart, also can infringe and be unreasonable as well. There's an unreasonable scare here. So they can't come up with something that's so out of the ordinary, right, that a reasonable person would not follow it. So
it's almost in my mind, how I conceptualize it is the community was built, let's say in the 80s or the 90s, and they come out with the governing documents, and the rules almost provide a opportunity for the association to develop additional rules as things change within the community. So for example, pickleball.
It's funny that you mentioned this because I was going to bring up this example. Say, hey, can we bring some practicality into this? Like, what happens? Yeah, pickleball was one I was going to bring up because it's. I've seen a lot of disputes arise because of the rise of pickleball.
Right, but when the CC&Rs were drafted, that didn't exist. Right, or it wasn't common. Right, right. It could have existed maybe in the 80s. I don't know, but let's say you look at the current state of affairs. It's everywhere. Right. But It allows for the association to keep up with the trends and the evolution, I guess, of the community to say, okay, we're going to have pickleball. It's silent in the CC&Rs. So let's develop rules around that space. So is that really the precise thing that we're looking at?
With pickleball, exactly the situation, Luke. Sometimes even we run into situations where the CC&Rs do provide rules about tennis courts. And then they're trying to pass a rule that conflicts with the tennis court rule.
Oh, that's interesting.
The rule trying to be changing the tennis courts into a pickleball court through a rule outside the CC&R when the CC&R provides for just tennis courts. So that's where we're finding some conflict there. But a lot of times they're silent on that. And that's where the pickleball rules will come in. And we're seeing a lot of them frequently.
Understood. Now, so let's go to authority and procedure. So the association, you have a new pickleball court. And they say, it's in the interest of the community to start articulating some rules around the space. What's the authority and what's the procedure? Let's start there first. What do they have to do to enact these rules? How do I end up with a printout? I'm a homeowner. How do I get that printout?
Yes, a procedure is extremely important, and it's under the Florida statute now. Notice must be provided within 14 days of any board meeting on these rules. Those need to not only be posted in the community, but delivered in advance to each owner.
Okay, so step one, that's the first.
So there needs to I think there's this important thing that we need to not gloss over is, does it require a board meeting in order to enact new rules?
Yes.
Yeah.
Of course. Rules are adopted by boards. If the CC&Rs normally provide for that as a general baseline. Some CC&Rs provide the rules have to be approved by the membership as well. So that would be in a membership meeting. So it would have to occur in a meeting, most likely a board meeting though.
Right. So in other words, a community can't necessarily get blindsided with that, the new set of rules. There's a procedure that they have to follow, and a lot of it is driven by notice. And the notice, I would imagine, is to give the community an opportunity to review and to speak up if they disagree. Would you say that's accurate? That's sort of the spirit driving this?
Yeah, it specifically discloses the rules that are voted on. A lot of times we're very vague. We're going to vote on a rule concerning landscaping. No, the rule needs to be printed out now and exactly in the verbiage that it's going to be passed in.
I think that's outstanding.
And what designates what needs to be voted on versus not voted on by the community? Like, for instance, we'll go back to pickleball because I'm kind of stuck on this now.
Same, I am too. Pickleball and golf carts.
Yeah. Let's just use the example of there's tennis courts.
Okay.
And no one uses the tennis courts, so they're going to start converting them to pickleball. But with pickleball comes a lot more noise, right?
Okay.
Not a problem when the tennis courts aren't used. No big deal. But now they are going to, because of let's call it the popularity of pickleball, they extend the hours now.
Okay.
Of the courts. So the rules now state that instead of the rules was it stopped at 5 p.m. and now they're pushing it to 8 p.m.
Okay.
Right. So in this example, Keith, do they have to, the board members bring it up? Does the community vote on it? What designates a community vote versus the board just passing it and then the notice going out? And then do the community members have a chance to reject it or put their hand up and say, I don't want this?
I wish I had a blanket answer for this one, but it really depends on your own governing documents. If there is a rule already in place in the governing documents about tennis courts or anything like that in terms of hours of operation, for example, that would need to be amended through the declaration, not through a rule, which would require a membership vote. Let's say it's silent, right? Then the HOA could pass a rule just with a board vote. The membership would be able to speak on the subject and obviously voice their concerns. But at the end of the day, the board's going to make a decision. And if they make a decision against the membership's interests, we'll see what happens at the next election, right?
Right. Yeah, they're not going to be very popular. So with that, now let's sort of segue into, HOA rules that are clearly unenforceable, right? I think we sort of understand the pickleball situation or the golf cart situation, but, let's say a board goes rogue. Where do they cross that line where it's clearly just unenforceable? What is that bright line?
There's a few areas here. So let's talk about first discrimination or selective enforcement of these rules. If they are going to pass these rules and apply these rules, they need to apply them across the board. Yeah. So if they target specific members or individuals, they are unenforceable.
Got it.
So that can't prohibit, discrimination based on race, sex, disability, religion, family status, and other protected categories.
Understood.
Or they'll be dealing with a HUD complaint.
Okay. What or do you see for unenforceability? What have you seen historically where a board, again, trying to overreach? I would call this overreach, just or abusing one's power. What else is it crosses that bright line for unenforceability in Florida?
There's been a couple modern concerns that have come up recently that have been unenforceable. So two of those are solar panels and charging stations specifically. Florida law safeguards against homeowners' rights to install solar panels and prevents HOAs from putting restrictive rules in place. And then charging stations, a very similar situation. Obviously, they want to protect the rights to install these EV for electric vehicle stations, and they can't ban these stations outright. And they may regulate them for like aesthetic purposes only, but the use of them cannot be banned. So these are just unreasonable restrictions on property use that the HOA is prohibited from doing.
Interesting. Okay, so
I think it bears repeating that there is a chain, if you will, right? There's federal law, then there's state law, then there's community ordinances. I would say, correct me,
city, local,
Yep. And then you've got your bylaws, right? As you go up the chain, nothing can be in contradiction with anything going up the chain, right? So for instance, if a bylaw is in direct violation of a federal law, it can't stand. It won't stand. Am I right?
Well, let's ask
your
Florida partner.
Definitely. Let's talk about something like right to bear arms, right? That's a constitutional right. A rule that prohibits residents from owning a firearm or keeping them in their home would be unconstitutional and prohibited. But the HOA can make rules about carrying firearms in public spaces, the community spaces, the ones they have control of. And moving to something even lower on the totem pole there, let's talk about city ordinances. Marty, you're concerned with the pickleball and the noise. APM might be actually against city ordinances. There might be a noise restriction past 7 p.m. or something like that, where this rule is interfering with a noise restriction within the city. So both of those rules, whether it's the right to bear arms at the highest level, of the Constitution, or at the lowest level of a city ordinance for noise, they both, if they contradict with those rules, if they contradict with either one of those, they're unenforceable.
Understood. So let's now back it out. I'm a homeowner. I'm in Florida. There's clearly a violation of, this new rule comes in. I identify that it's a violation, whether it's city ordinance or it's constitutional on the extreme. What do I do to challenge this rule? What do I do as a homeowner? What are the practical steps that I need to take to alert the board that there's been overreach, there's an abuse of power? What does a Florida resident do in that situation?
Well, you could start by reviewing your rules in the first place. So in like the movie Scream, for example, you have to know the rules of a horror movie to survive. And living in an HOA can be a horror story sometimes.
I didn't expect that reference, but that was a great reference.
Just don't take a shower.
Yeah,
that's
exactly. Don't
pick up the phone. Don't split up.
Exactly. You need to know the rules in place. And living in an HOA could be a horror show sometimes. We know that. So reviewing the rules and knowing them ahead of time protects you. So let's say, for instance, the recent law signed by DeSantis, right? Governor DeSantis here requires HOAs to now, I've mentioned 14 days notice to provide for new rules. But they need to furnish every member now of the association, as well as future members, with either a physical or a digital copy of all the association rules and those covenants you referred to earlier, Luke. So getting those documents, DeSantis allowing the homeowners to not only have access to them, but make the HOA required to provide it to the homeowners, educates the homeowners that much better and allows them to survive in an HOA environment where they can avoid violations for these rules that they would never have known of in the first place.
So empowerment, right? Empowerment through the knowledge. Exactly.
And then, as well, if any amendments occur, they have to update you on those rules also as well, provide you copies there. So education is key. So once you educate yourself, then you might have a ground to challenge, right? You're learning your rules, your constitutional rights to some degree, what the noise ordinances is, what you're challenging the rules on. That can involve filing a complaint with the board at that point to bring their attention. It can also, like I said earlier, for the rights of a homeowner to provide a complaint to HUD. And pursuing even legal action at that point if those
What's
fail.
HUD? Sorry, I'm unaware of what HUD is.
It's the U.S. Department of Housing and Urban Development. So it would, So that governs any of these type of complaints having to do with unequal housing in those protected categories I mentioned earlier.
So, I'm running this through my head, and we see this time and time again in California. I know you guys see it in Florida. The homeowner goes to the board, lays out the law, it says, here's the violation, and you have an association which says, cool, go kick rocks. We're going to do nothing. We're not going to help you. Sorry, we have all the power. And, the homeowner's first option was to act reasonable with the board. But now they got shut down. At that point, one could argue now you're sort of looking at maybe bringing on a lawyer, having a lawyer intervene. You actually bring on an advocate on your behalf. And so I want to talk about that. I think the trigger there is you're getting no traction with the board. You get shut down, notwithstanding the fact that you have these really strong legal arguments. Sort of walk us through that process. When you actually bring on a law firm, when you hire a lawyer, what does that look like? What are best practices? What would you recommend, in terms of executing on that plan?
Excellent. If you're looking for an attorney to assist you, there's multiple ways to go about it. So probably the lowest in terms of making waves that you can is having, after engaging an attorney, of course, to write a letter to your association, is getting a legal opinion or a demand letter to the association, which explains why that specific rule is unenforceable or even illegal, and make the demands to either revoke the rule and any penalties that were in place because that person was damaged by that rule specifically. And that could be even done by a layman. While, it helps to have an attorney's letterhead on time, bringing it to the HOA's attention through that letter, but you're talking about, hey, that letter failed. Sometimes having it said by an attorney brings it to the HOA's attorney's attention also, and that could get the ball rolling.
And that's an interesting point. We see that a lot in California. Sometimes these things die in the association or with the board. They don't go any further. But by bringing in an advocate, by bringing in a lawyer, that letter then goes to the attorney. And if it's a good association attorney and you articulate, or that attorney articulates the position well, that attorney should say, you know what, actually, this was a mistake. Let's roll it back. And let's, it's sort of the adult in the room on the other side.
Right.
But your letter might never get to that point until you bring in that advocate. Because, obviously, whenever a lawyer letter goes out, there's an undercurrent of potential litigation. Most associations just don't want to get sued. So it sort of heightens the degree of the attack, so to speak, on the board. Okay, so that's a demand letter. Are there other alternatives that the attorney has at their disposal when going after a bad HOA?
Yes. Like we mentioned earlier about these declarations and covenants, if an association violates that by passing a rule that's unenforceable or contradicts with that, that would be a breach of those governing documents. And such an action like that requires you to take your association to mediation ahead of time if you even wanted to sue them. So mediation and alternative dispute resolution is a great avenue if that initial letter does not work. It gets the parties in the room together to discuss these issues and iron out the details. Sometimes it helps to get the parties together and actually find out what's important to each party.
Understood. So that's sort of the next level of pressure you can put on the board, and it actually forces them into a situation where there's a neutral facilitator, which is the mediator, and hopefully at that phase, things are worked out, assuming the other side is reasonable. But let's say you go through that. You're at the mediation. The retired judge who's the mediator says, the association is 100% wrong, but the bad HOA keeps wanting to be the bad HOA. And they say, you know what, we're still not going to budge. We don't care that we're in violation of the Constitution or local ordinance. We're so committed to this position that we're not going to move at all for you. What can a homeowner do then? Does it dead end in the mediation, or are there additional steps thereafter?
There are additional steps other than just filing a lawsuit, which I'll get to in a moment. A lot of times I could just, from my experience, they may make that position at mediation, but then a day later you receive an email from the attorney from the other side going, let's get back together and figure out where we could reach a common ground.
Right.
Once the realization that a lawsuit may be coming. But that might be the next step. And luckily for homeowners in Florida, they have some relief there. If they're going into an action like this for breach of governing documents and these rules, they win, they'd be entitled to their attorney's fees if they win. So it kind of gives you an opportunity to go after your association and make them pay for your bill for your attorneys for going after them. So these type of causes of action, luckily Florida allows homeowners to recover.
So there is a pathway even after mediation. And I go to this original premise too, and I see this a lot. Most associations don't want to get sued because they know, in California, similar. It sounds like Florida is also similar, that upon prevailing, they're out the attorney's fees as well, in addition to whatever other damages, right?
Yeah. And they don't. I'm assuming they don't want that lawsuit in the public domain. It's
bad all around.
Yeah.
So, okay, that was very good. Thank you, Keith. And I know Marty has a very exciting, I think, next step for this. It's a pop quiz, if you will, for lack of a better word.
For the people that
go.
For the people who see the show, they'll know what's coming.
They'll know what's coming. But for Keith, this should be exciting. I always like throwing Luke a curveball on these.
I like these.
So, for the people that don't know, there is some spicy Reddit subreddits specifically about people that have a disdain for their HOAs. I mean, bad HOA is an understatement on those. It's just people ranting and raving about their horrible HOA. So we will grab a story or a post that someone just needs some guidance, or they just have a dispute that they want to air out in the public, and we'll grab one. I grabbed one from Florida for you, Keith, so you can look at it through the lens of Florida, and then we'll let you guys debate it a little bit and see what you can do, or what tips and tricks they might try through you guys' lens as HOA attorneys.
And as a lawyer, we always throw out the fun disclaimer that it's not actual legal advice. So Keith, don't worry. This is a
big red thing coming in, not legal advice.
Look at this as a bar exam question, right? Look at it clinically, and how would you approach this? From your perspective as Florida lawyer, giving general recommendations, not to anyone specifically.
Yeah, open-ended. Okay, here we go.
You got it.
We need an experienced attorney to help us navigate what appears to be blatant election fraud and board misconduct in our condo association. Our board of directors has remained unchanged since 2021, and with two of the three members having deep financial ties to our property management company. Owners have been systematically denied access to records, meetings, and the ability to participate in board elections. Despite repeated requests, we have been ignored, misled, and stonewalled at every turn. Our community's only election in 6 years was announced with an incorrect date, and crucial notices required by Florida have not been sent. Meanwhile, the board has mysteriously changed on state filings without an election ever taking place. Our committee has secured a state-appointed election monitor, but we are concerned that the ballots will be manipulated, suppressed, or ignored. We need urgent guidance on point number 1, preventing election interference and ensuring the ballots are counted. 2, challenging the unauthorized board changes. 3, holding the board and PM, I'm assuming property management, accountable for violations of Florida HOA laws.
Oh, that's a spicy one. I want to know your general thoughts on this one, Keith, because that was a lot in there. That was packed.
This was
packed to the brim.
And this is in Florida, but again, this is not advice. This is just
an exercise, if you will, legal exercise.
Just looking at it and you can say, yeah, that's spicy. They should consider it.
They should get a lawyer.
Yeah.
Your take, Keith.
Well, election issues this seems to encompass every single election issue that we've ever had in the firm in terms of just one HOA. I mean, not holding elections, not, noticing it properly. These are all individual items that could get an HOA in trouble. It seems like they are already on the process of getting taken care of. But in terms of making sure the ballots are counted correctly, your HOA is actually required to have the ballots in their official records for the last year. Any records of that, you can make an official records request and view the ballots and the counts to confirm that. So that's number 1, is use your right as a member. You don't need an attorney for that. You can make that right. It's your right as a member to request those records. So that's the number 1 thing I would say to them.
Can I ask a question on that? So ballot comes in. I'm assuming they're not anonymous. I don't know. I would assume that when you are filling out your ballot, it's got your name, it's got your address. You fill it out. You say who you want the board members to be. So that information is then public for a year at that point. So then you could theoretically, if I'm distilling this down, I could get everyone's ballots and I could go to the homeowner and say, is this correct? Did you actually vote for this person, to validate whether or not that election was fair? Did I understand that correctly?
You can but you run into one homeowner who's friends with a board member and they start complaining to the board member, this person's harassing me over my past votes. You might be getting a letter in the mail to stop going around and talking to members about election issues. Doesn't mean it's a proper letter. But it seems like this board is pretty defensive here, so they would probably take action against this potential member.
But so you might go to your neutrals, like that. If there's some neutrals just to validate. Okay, thank you for the clarification there. I was unsure. You continue. My apologies.
Oh yeah. Well, there's ways of challenging these elections as well. Unfortunately, elections need to be challenged in Florida within 60 days of the election. If I'm not mistaken, not legal advice here. I'm going off the top of my head, but they need to be challenged pretty quickly and through arbitration as well. So it is a fast process, and it seems that they are really on top of their board. So if these members are looking to do something like that, they would need to act quickly, and it seems that they're monitoring the situation, so they would be able to react in such a way.
Interesting.
Very interesting.
Yeah, that was a spicy one.
Yeah. So is this one of those? In your opinion, is this one that you would recommend pursuing legal counsel, an attorney, because from the chair here, it looks like, oh, hey, well, if you want to challenge this at all, and it needs to be within 60 days, and it has to be through arbitration, all it screams to me is get yourself an attorney to assist.
Yeah, are they in lawyer land here, Keith, or what would you advise, especially with arbitration? Jeff Kaminsky, our partner in Florida, he went through the arbitration process, and the difference between arbitration and mediation. And arbitration is a different beast altogether.
Oh yeah, and who's in charge of arbitration here in Florida likes to get rid of these things quite easily. I mean, if you are insufficient in terms of your notice to the assessor, first you have to give them notice you're going to even file an arbitration petition. And I can tell you, when we've come into play with these election disputes, when we send out that notice, we actually, every single time I've had it, they respond to the notice and they don't want us filing the petition. I've had elections overturned, and one of the members that I represented pointed to the board because he came in second place with an illegitimate election. So sometimes the notice is enough, but you have to send that notice before arbitration anyway. And if you're going to be sending that notice out, the arbitration petition process is a very treacherous process, even for an attorney. So getting an experienced attorney, not only getting an attorney, but getting an experienced attorney in that area. Like Jeff mentioned, he says it's great experience there, and so do I. That's the most important thing, because there is plenty of ways that could go wrong. And if gets dismissed within that 60 days, you can't refile. It's done.
So this is one where you wouldn't give yourself a root canal. You wouldn't do your own root canal. So maybe it's similar. You wouldn't do your own arbitration. So.
Oh yeah.
Perfect.
All right. Well, listen, Keith, that's all I think we have. Marty, did you have anything up your sleeve?
No, I mean, no. This is fun as usual. It's always nice to get some other takers on the show.
I love it, Keith. That was phenomenal. Thank you so much for taking time. I know you're so busy in Florida, but I wanted to thank you for being on the show.
Thank you for having me. It's been a pleasure. I can't wait till the next time.
Same. All right, guys. Well, thanks for watching. If you enjoyed the show, subscribe, and then also leave comments. We love the comments. So appreciate it, and we'll see you next time.